Personal injury claims can be confusing, and there's a lot of misinformation floating around. If you've ever been injured in an accident, you've probably heard a few myths that might make you hesitate to file a claim. Well, I'm here to bust those myths wide open. Myth number 1, I can handle the insurance company on my own. Dealing with insurance companies can indeed be far more complicated than most people expect. Insurance adjusters handle claims day in and day out, and they are trained specifically to minimize payouts to injury victims. Adjusters will use various tactics, such as lowball offers, delaying settlements, or attempting to get you to say something that can weaken your claim. If you're unfamiliar with how insurance companies operate, you might accept far less than your claim is actually worth. Having an experienced lawyer on your side ensures that someone who knows the tricks of the trade is standing up for your best interest. Injury lawyers are familiar with the tactics insurance companies use to reduce payouts and can effectively counter them. They know how to build a strong case, gather the right evidence, negotiate for a fair settlement, and even take the case to court if necessary. Without this legal knowledge, many injury victims unknowingly accept settlements that don't fully cover their medical expenses, lost wages, pain and suffering, or future costs associated with their injuries. Additionally, having a lawyer handle the communications and negotiations with the insurance company can relieve a lot of stress for you. After an accident, the last thing you want to do is navigate the complex web of insurance policies, legal jargon, and endless paperwork. An experienced personal injury lawyer can take over this process, allowing you to focus on your recovery. By hiring a lawyer, you're not just getting someone to handle the legal work, you're giving yourself the best chance to secure the maximum compensation you deserve. Myth number 2, if I'm partially at fault, I can't get any compensation. This one's a big misconception. Even if you're partly at fault, you may still be entitled to compensation. In the vast majority of states, you can recover damages even if you're partially at fault for the accident. Don't just assume you're out of luck. Talk to a lawyer in the state where your accident occurred who can explain how fault is determined in your case. For example, I practice law in Kentucky. Kentucky is a pure comparative negligence state. This means that an injury victim can recover compensation even if they are 99% at fault for the accident, so long as they can show another party was 1% to blame for the accident. The compensation awarded to the injury victim is reduced in proportion to their percentage of fault. So if you were injured in an accident in Kentucky and were deemed 80% at fault for the accident, but another party was deemed 20% at fault for the accident, you would be entitled to recover 20% of your damages from that other party. So if you had $100,000 in damages, you would be entitled to recover $20,000 from that party. I've personally represented numerous clients over the years that were at least partially at fault for their accident, and at the end of the day, almost always got those clients a good result. Thus, I would strongly encourage anyone who might be thinking that they are out of luck and won't get any compensation because they may be at least partially to blame for their accident to consult with a lawyer in the state where your accident happened. You may just be surprised to learn that you may just have a case worth fighting for fair compensation. Myth number 3, if the other party is liable, I will definitely get paid for my damages. Just because someone is legally responsible for your injuries and damages does not necessarily mean you will receive compensation in your case. In many cases, if the liable party does not have the financial resources or insurance coverage to pay for your claim, you will face significant challenges in getting compensation at all. Tracking down insurance in a car accident case is usually crucial to getting paid. It's also crucial in a dog bite case. In a slip or trip and fall on a business premises, typically the business will have insurance or be self-insured. If the liable party in your case is judgment-proof and has no insurance, you are likely out of luck of getting any compensation. A person is considered judgment-proof if they do not have sufficient assets or income to pay a court judgment even if you win your case. So while the court may recognize that you are owed money, collecting that money from someone without the means to pay becomes nearly impossible. This is why it's critical to have uninsured and underinsured motorist coverage on your automobile insurance policy. Uninsured motorist coverage protects you in cases where the at-fault driver has no insurance at all, while underinsured motorist coverage helps when the other party's insurance isn't enough to cover the full extent of your injuries and damages. These types of insurance coverages essentially step in to pay for your damages when the at-fault party cannot. Without these coverages, you may end up paying for your medical bills, lost wages, and other damages out of your own pocket, even though someone else is responsible for causing the accident. No matter how clear-cut the case is or how responsible the other party is for your injuries, you are at risk of walking away empty-handed if there is no insurance to pursue or the other party lacks insurance and also doesn't have any significant assets. Myth number 4, I'll have to go to court. Simply put, many personal injury claims don't end up in court. Many personal injury cases do not go to court for several reasons, with one of the most prominent being that settlement negotiations typically resolve the matter before the filing of a lawsuit or trial is ever needed. Insurance companies and attorneys on both sides often prefer to avoid the cost, time, and uncertainty of litigation or a trial. And it's often the case that avoiding court is in the best interest of the injury victim as well, to avoid the time and effort of fighting the claim in court to possibly only get a little bit more money than what the insurance company is offering. Myth number 5, I can't afford a lawyer for my personal injury claim. This is probably the biggest myth of all, because everyone can afford a personal injury lawyer. You see, every single lawyer I know, including myself, in my firm, works on a contingency fee basis. This means you don't pay anything unless your injury lawyer wins your case. Hiring an injury lawyer on a contingency fee basis provides significant benefits. One of the primary advantages that it allows is injured parties to access legal representation without any upfront costs. This is particularly important in personal injury cases where victims may be dealing with financial stress from medical bills, lost wages, and other expenses. With a contingency fee arrangement, the lawyer's payment is contingent upon the success of the case, meaning the attorney only gets paid if they recover compensation for the client. This ensures that individuals, regardless of their financial situation, have the ability to pursue justice and hold parties accountable. Additionally, when a lawyer works on a contingency fee basis, they are highly motivated to achieve the best possible outcome for their client. Since the attorney's compensation is directly tied to the amount they recover, they have a vested interest in maximizing the settlement or court award. This can result in more aggressive representation, thorough investigation, and strong negotiation tactics that ensure that the client will get the compensation they deserve. The thing is, now that you know that the common myths that I discussed in this video about personal injury claims are not actually true, you might be wondering what could be done to boost the value of your injury claim. And if that sounds like you, I highly recommend you watch this video about to pop up right here, where I reveal several secrets that can boost your injury claim. Also, if you found this video to be helpful, don't forget to subscribe to my channel right here for more helpful videos like this one. Lastly, if you've been injured in Kentucky, remember to